All right. And I do apologize for the delay today. Counsel?
Yes, Your Honor. Thomas Goosebank, Your Honor, appearing on behalf of the city of Wyandotte.
Okay, thank you. So today is the date scheduled for the adjourned pretrial. And counsel?
We're asking that the matter be set over so they provide discovery and/or I'll file another motion.
Well,
Right here is the first red flag. The judge ordered discovery within 21 days. That's not a suggestion, that's a command. In criminal court, discovery deadlines protect the defendant's constitutional rights. Miss this, and the entire case can start to wobble.
okay, well, let's see. We held the motion hearing November 5th. And I ordered the prosecution to provide discovery within 21 days. So what happened?
If I may, Your Honor, the motion was held. Mr. Mays had produced the order. We approved it. Court entered the order, I believe, on December the 4th.
And here's the controversy. The prosecution is saying discovery exists, but only if the defense pays nearly $90. That raises a serious legal question. Should a defendant have to pay to receive evidence that could prove their innocence? Drop a comment. Should discovery ever come with a price tag?
We made contact with the records department for the city, and the records are available. However, the issue is Mr. Mays is reluctant to provide the payment of $86.92, for the records. They are available immediately, but I spoke with the chief of police, who indicated that the procedure is that this is a charge that has been followed, and of course, former process or continuing process is the fact that retained counsel would pay for the discovery. So we are at an impasse, Your Honor. We need some direction because Mr. Mays does not want to provide the payment. We cannot secure the discovery to provide to him. Now, prior to that, we did provide Mr. Mays in September with a copy of the police report prior to there was going to be an implied consent hearing, which was resolved. And we also made contact on behalf with Mr. Mays with Michigan State Police, who I believe provided Mr. Mays with a rather substantial blood test results. So the issue is the remaining materials that are in the police report.
Okay, so let me just clarify. So it's not the court's procedure for charging for discovery. That's something that the Wyandotte Police Department is charging for copies or, I don't know, digital stuff. I'm not sure. So, Mr. Mays, the discovery is available to pick up, correct?
No. The prosecutor's not served me with discovery.
This is where things turn hostile. The defense isn't just frustrated, they're threatening dismissal. That's the nuclear option. If discovery isn't properly served, courts can dismiss charges entirely. The tension here isn't personal, it's procedural, and procedure decides cases.
That wasn't my question.
I don't know what all conversations the prosecutors had with the police or anybody else, Judge, and I don't care. They can file a motion if they want, but all of what you just heard is a whole bunch of nonsense. The prosecutor has not served discovery, period. You ordered it. They've got a couple more weeks. I'm going to file another motion to dismiss.
So it sounds as though the prosecution has the discovery available, counsel, for you, but it sounds as though there's a cost issue.
No, not as far as I'm concerned. They have not served discovery, period.
Your Honor, we would totally object to that comment. We have served Mr. Mays with discovery on 2 separate occasions. We have further advised Mr. Mays by both email and telephone conversation, which Mr. Mays has acknowledged in return messages back as to the questioning of the validity of the invoice. Your Honor, there's an invoice for $86.92. Discovery is available. I can't go to the police department and take it out of the police department. It has to be released. And the records department will not release it without payment of the fee. Now, Mr. Mays has cited in the past the court order. Now, not the court order, but excuse me, the court rule. Court rule is silent as it relates to the payment of this discovery. And so Mr. Mays can have all the discovery. We'll be happy to walk up the steps that provide, so long as Mr. Mays provides the payment. We've even suggested that to him. If he made direct payment, we would secure, because Mr. Mays was reluctant in the past to ascend to the second floor to get it from the police department. We would be happy to secure that and provide it. It's just that we need $86.92.
Your Honor, I've not been reluctant. This has already been briefed. I've already briefed it. They had no response to that, to the entire portion of that argument.
Of the monetary.
That's correct. I'm not reluctant. They have yet to provide any authority for it. I've indicated by motion
Authority for what?
for charging for discovery.
Important legal moment. The judge clarifies something critical. Court rules may be silent on cost, but silence doesn't equal permission. When rules are unclear, judges rely on discretion, and discretion can make or break a motion. This is where law stops being black and white.
The court rule is silent as to that.
I've already briefed it, so it is not silent to it. I have already briefed.
Counsel, just because you briefed it doesn't mean that the court rule is not silent as to cost. It leaves it in the court discretion as to cost.
No,
Yes, it
it
does.
is not up to the court's discretion.
Counsel,
There are procedures that they need to follow. They have not.
Counsel, as to costs of discovery, it is up to, there is judicial discretion as relates to cost of discovery. Now, there is a procedure for that. You're correct. There's a procedure for that. So, apparently if somebody's going to be filing a motion as to costs, I guess we'll set it for a court date. We'll set it for a motion hearing. But, absent that, apparently you already have, you have discovery from the Michigan State Police, correct?
I have some.
And you also have some other discovery, correct?
Okay.
So just so that the record is clear, what discovery is it that you are still awaiting?
Judge, it's outlined in my motion.
Counsel,
They
I'm just
know-
asking for the record right now, what is it that you are requesting that you still do not have for discovery?
It's contained in my demand for discovery.
Counsel, I'm not reviewing that right now on the record through the written paper. I'm asking you to state it for the record, so we have it on the record, please.
Well, I can read it off. Let's see.
Yeah, please keep your hands on your pockets. Thank you.
Okay. In my appearance, we requested production of all police reports.
Counsel, what I'm asking for is what you do not have yet. So you said you have some discovery. So what discovery are you still requesting that you do not have?
I've got to go through it, Judge.
Well, but you also have received some discovery. So you said all police reports. Did you receive any police reports?
I received a police report.
Okay.
Yeah, I'm looking at the police report that I've got. And again, as you stated earlier, I've got some materials from Michigan State Police.
Somehow.
But in terms of what I've asked for, let me pull that document back up.
It's my people.
We asked for police reports, patrol car videos, 911 calls, and station house videos capturing my client's driving, detention, arrest, and
Counsel, I need you to slow down while I'm writing all this down. Okay, please.
It's all part of the court file.
Police reports,
Yeah.
patrol car videos,
911 calls, station house videos. Those were indicated to be exculpatory. And then we asked for exculpatory information. We asked, again, in discovery demands for police reports, written and recorded statements.
of whom?
by Ms. Volumenis, a co-defendant, an accomplice, even if that person is not a prospective witness at trial.
Is there a co-defendant in this case?
I don't know.
No, there is not, Your Honor.
Okay.
Notice the shift here. The judge starts pressing the defense for specifics, blood test or breath test, warrant or no warrant. Judges don't like vagueness. If you argue discovery violations, you must know your file cold, or credibility starts slipping fast.
An affidavit, warrant, return, pertaining to any search or seizure.
Was there a search of blood in this matter?
I don't know.
Well, counsel, what do you mean you don't know? Was there a breath test taken or was there a...
You want me to read off my discovery demand? This is what's been this.
Counsel, I'm asking,
Ma'am.
was there a search warrant for blood?
Let's ask the prosecutor. Was there?
Counsel? Was there a breath test that was performed or was there a blood analysis that was performed?
I think it was blood, Judge, but don't hold me to that.
Well, I am. You're the defense attorney that's representing your client.
Oh, I'm sorry, Judge. I have an incomplete discovery file after months.
Counsel, you have the MSP reports, correct?
Would you like me to open those?
No, I'm asking, do you have those?
I have some materials from the
Okay,
state.
and so is that referencing that there was a blood test or a breath test?
No. It's gas chromatograms, so I guess that would be blood.
So you're asking for the search affidavit and search warrant for the blood test, correct? Or for the,
I'm asking
for the blood.
any affidavit, warrant, or return pertaining to a search or seizure in connection with the case.
And I was asking to make sure that there was one that existed, potentially existed, or did not exist. Because if there was not a blood test, then that would not likely exist. So that was why I was asking that question, counsel.
Understood, Judge, but again, this is all covered in my last motion.
Counsel, I'm aware of what was covered in your last motion. I want to make sure, we're going through all this so that we can have a clear understanding as to what discovery that you are stating you do not yet have.
Yeah.
And then I'm going to go on to my next set of questions.
Okay.
So that's why I'm asking.
All right. Then I asked.
As a retained defense attorney or any defense attorney, I would expect some of this stuff you would have knowledge of as to whether or not it's a blood or breath test. That is why I asked you.
Okay. So then I asked for any plea agreement, grant of immunity, or other agreement for testimony in connection with the case.
Does any of that exist?
No, it does not, Your Honor.
Okay, so that's not even necessary.
Well, it's necessary that they respond. So I'd ask the court not to make these sort of flippant decisions. This is for them to respond to. That's the whole point of giving them notice, months of notice, I might add.
So first of all, this court does not make any flippant statements. What this court is stating is that we're having an on-the-record discussion, so that right now you at least have the information that there aren't any such plea agreements based upon what the prosecutor just stated.
Well,
What's the next thing that you're
let's back up to exculpatory.
what's the next thing that you're requesting, counsel?
I asked if there was any exculpatory information. That was the first thing I read off.
Counsel, you're going through a police report. I'm writing all this down.
Exculpatory.
I'm going back. I'm going to go read. I'm going to go back and address some of this. I'm waiting for your list.
Okay. The names and addresses of all lay and expert witnesses whom the prosecuting attorney intends to call at trial.
Okay, next thing.
Any written or recorded statement by a lay witness whom the prosecuting attorney intends to call at trial, including all 911 recordings, videos, or other audio recordings.
So some of this sounds similar to the first list you gave me. The 911 calls. Okay.
The curriculum vitae of any expert the prosecutor may call at trial in either a report by the expert or a written description of the substance of the proposed testimony of the expert, the expert's opinion, and the underlying basis of that opinion. And in blood testing cases, this request specifically includes a request for the full litigation packet, including all sample prep, chain of custody, standards, controls, and data pertaining to the underlying GCFID, GCMS, and/or LCMS-MS documents pertaining to blood analysis that provides a basis for the expert's opinion, as well as notes, printouts, and copies of the complete run identifying the specific device used and employed and its maintenance records.
Okay. Is that the extent of your list?
No,
Your
it
request.
continues. Any criminal record that the prosecuting attorney intends to use at trial to impeach a witness, any document, photograph, or other paper that the prosecuting attorney intends to introduce at trial, including all video and/or audio recordings, including body cams, in-car cameras, and booking room video, and a description and an opportunity to inspect any tangible physical evidence that the prosecuting attorney intends to introduce at trial, including all expert witness materials that might be introduced pursuant to MRE 703, and in all blood testing cases, release of the second sealed blood sample to Ms. Volumelis independent laboratory for independent testing by a qualified forensic laboratory. And that was requested, it was mandatory within 21 days, dated, August, 4 months ago. Before my motion was filed.
So out of that list of items, counsel, which pieces of discovery have you received?
I have a police report.
Dated when?
Let's see. Police report. That police report was printed on September 4, 2025.
What's the date of the report?
That's, the date of the report. There's a status date of June 30th, 2025. I can't quite tell. And it is 7 pages long.
Okay, but you have the report. So on the first page, I believe somewhere at the top, there's a date of incident or something.
It's got the incident date, yeah, but that's not the date that the report was necessarily drafted. And it was,
Okay, and what else have you received?
let's see. Oops, I can't open this last one, it's not opening on my thing, but approximately 2 months ago, I got some materials from Michigan State Police. And that's it.
Okay, and what are those materials, counsel?
Judge, I can't go through all that. Like I said, it won't open on my phone.
Do you have a summary of a description of what it is?
No.
Are they reports? Are they, is it analysis?
Some records from Michigan State Police,
Okay,
but I can't open it to give you a comprehensive list because it's not open on my phone.
okay. So, Mr. Kuzmiak, you hear the discovery that Mr. Mays has indicated that he's still requesting. And are those items included in that, in the packet that you're indicating is available upon the payment of $86.92?
Your Honor, I believe the vast majority of those items are included in that packet, including the videos and the statements that Mr. Mays has indicated. It was at 9525 that we provided him with the police report that we had secured. And it was on October 17th of 25 where we did confirm with Michigan State Police that they had forwarded the materials, and the staff of the Michigan State Police indicated they knew exactly what Mr. Mays was requesting, so they would be sending them the package, that would be from a discovery perspective. So, Your Honor, if we could secure the records from the records department, we would be more than happy to deliver those to Mr. May. And I do believe many of these items that he has addressed would be included.
Okay, well, prosecution says that they have the discovery ready for the defense, and you submitted an invoice to Mr. Mays?
We sent an invoice to Mr. Mays. Mr. Mays acknowledged the invoice. He sent us an email indicating under what authority did we have to send him an invoice. We weren't sending him the invoice to reimburse our office. We were sending him the invoice to pay for the record so that we could secure them.
Like I said in my original motion, Judge, garden variety drunk driving cases have become a lucrative source of financing for local police departments. And that ended when the Michigan Supreme Court promulgated the discovery rules and said, no more. This is no longer a profit-generating device. The prosecution had no response to that. And yet they turned around, they provided a proposed order that would have, again, hey, Mays, pay this bill so we can make a little bit of extra money off of our DUI cases. And I said, no, I filed a motion. They don't respond to that allegation. The court heard the arguments on it. And like the prosecutor's admitting now, I said, by what authority are you charging for this? No response. No response. So, with no authority for that, and the court rule and the order existing, I'm going to be moving to dismiss yet again. If the police don't want to provide this to the prosecutor, then I guess that's just a gosh darn shame. That all said, though, I wanted to refocus the court's energy back at that exculpatory evidence that I pointed out earlier, because the court didn't ask any questions about it. If I understand the prosecutor correctly, there are videos in this case.
This is the breaking point. The defense invokes Brady, the rule requiring prosecutors to actively look for evidence that helps the defendant. Accusing the prosecution of ignoring potential exculpatory evidence is serious. The judge shuts it down instantly, not because Brady doesn't matter, but because speculation without proof can poison the courtroom.